Okay, I see folks are still joining, but we're going to get started since it's 12 o'clock. Welcome everyone to today's webinar called Who Decides? Busting Legal Myths About Enduring Powers of Attorney and Personal Directives. My name is Jessica Steingard, and I'm a staff lawyer here at the Centre for Public Legal Education Alberta, or CPLEA for short. And we also have Jennifer Locke joining us, and I'll introduce you further in a moment, Jennifer. We'll do some quick intros, and then we'll get underway. So today's topic, we're going to be talking about what really happens when someone makes decisions for you, what responsibilities do they carry, and what should you expect in practice. Okay. We are also, I'll mention now, we're actively posting stuff in the chat, so make sure you follow along in there. We'll also be posting some resources near the end, so just a note to keep an eye on the chat there as well. Before going further, the Centre for Public Legal Education respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories, and we respect the histories, languages, and cultures of First Nation, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community today. We are talking about legal topics today, so I have to give a disclaimer because of that. And my disclaimer is that this presentation contains legal information and is not intended to be legal advice. I also want to acknowledge the generous funding we receive from the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation that make presentations like this one possible. Okay, so as I said, my name is Jessica. I'm a staff lawyer at the Centre for Public Legal Education Alberta. And what does CPLEA do? Well, we produce free resources that help people understand their rights and responsibilities. So we have a variety of websites and PDF resources and print resources and videos and webinars like this one that explain the law in easier to understand, hopefully easier to understand language and make it more accessible for everyone. And like I said, we'll be posting some links in the chat to some of our resources relevant to this topic as we go. And I said we have Jennifer joining us. Jennifer, I'm turning it over to you if you can introduce yourself as well.
Certainly. Thanks so much, Jessica. So my name is Jennifer Locke. I've been a lawyer here in Alberta since 2012. Just had my big bar crawl anniversary at the end of September here, so that's quite exciting. I've had my own firm, River Rock Law, named after a painting that my late mother did of River Rock, so as a tribute to her. And I am a wills and estates lawyer, and I also do some residential real estate as well.
Awesome. Well, we're so grateful that you're joining us today to share your knowledge with our with our audience. Before we move into some myths, which is going to be the main part of our presentation today, we're going to be looking at some myths that we hear around personal directives and powers of attorney. I'm going to start with a little bit of an intro, make sure we're all on the same page about what are we talking about when we say enduring power of attorney or personal directive. So a personal directive, some of you may be familiar with, sometimes it's called a living will, and it is a legal document in which you can name someone, named an agent, to make decisions for you. Specifically personal decisions, so medical and other personal decisions for you, if you lose capacity. So that means that you are no longer capable of making decisions for yourself. So that's a personal directive. And on the flip side, we have an enduring power of attorney. And it is also a legal document in which you can name someone called an attorney to make financial decisions for you. And this document usually comes into play once you lose capacity, although you can have it start earlier if you choose. The document can say that. But that's what we're talking about. So these two documents that are used while you're still alive, but don't have capacity to make decisions for yourself. And so instead, you are naming someone else that you trust to make decisions for you. And they're going to communicate those decisions to doctors, home care providers, financial institutions, etc. These documents are different from a will. So a will is only used once you pass away. And in a will, you say who's going to deal with your estate and who's going to get everything. But these documents are different from that. When we talk about capacity, we're talking about the ability to make a decision and to understand the consequences of that decision. And usually capacity is determined by medical professionals in lots of cases, but lawyers also have they can do some on-the-spot assessments to decide whether or not they think you're capable of actually making a legal document as well. So that's a kind of brief intro to our topic. I think we'll flesh out more as we go through. Did you want to add anything, Jennifer, before I dive into the first myth?
I think the only thing, and I'm going to underscore this at the end of our conference here too, is that it's really important that everybody have all three. Okay,
Mhm.
having a will, a power of attorney, and a personal directive. All too many times, I see people who are only interested in doing a will, who maybe never even heard of doing a power of attorney or a personal directive. I really, in a way, and having my own journey, and I'll talk a little bit about my own journey, my own experiences as acting as somebody's agent and attorney when they became mentally incompetent. The powers given by those powers of attorney and personal directives are so important. In some ways, they might actually even be more important than the will. So I cannot impress upon everybody attending enough. These are really critical documents, and the power of attorney and personal directive just as important as the will. Okay.
Mhm.
So I applaud you all for attending today. And the only thing I can say is start spreading the news because people just think about the will. They do not think about the
Mhm.
power of attorney and the personal directive.
And hopefully, as we move through the myths today, it'll empower you even more to think about making these documents, or you'll continue to see the benefit of making them. Because I think some of these myths we're going to talk about are the reason why people don't think they're as important as they are. So, with that, let's dive into the first one then. We're going to start by talking about some myths around personal directives, and then we'll move into some myths around enduring powers of attorney. So, personal directives, like I said, sometimes called a living will, but a document which you name someone to make personal decisions for you when you're no longer capable. So the first myth that we often hear is if something happens to me, my family can automatically make healthcare decisions for me, and thus I don't really need a personal directive. Is that true, Jennifer?
No, it is not. So, of course, we had the Personal Directives Act come into effect because there were some issues. I mean, if we talk about rate of divorce or separation, and it's getting to about, one in every two unions, do you really want somebody that you're making, that's considered your spouse or your common law partner, making decisions about where you might be placed in a long-term care facility if you're getting help, or even that great decision of are they pulling the plug on you? No. Same thing, unfortunately, too. We see sometimes children are no longer in the lives of their parents for one reason or another. Unfortunately, it's often due to some drug use, right? So, do you want somebody who's perhaps angling to try and have you die faster in order to get a payout on your estate, making a decision about what's happening with your treatment? Probably not. Okay. And so, for these reasons, we came up with the idea, our government said, let's put in some legislation to actually reduce it in writing. Never mind the fact that when it comes to next of kin, it's very complicated. We can have people who are in a common law union, but are not divorced yet from their first wife. So, who gets the right in that decision? So, next of kin is not clear. That's why we have to write it down. We have to reduce these instructions into a personal directive.
Absolutely. And and the bottom line is yes, that the law does not give anyone an automatic right to do it. It is your choice to name someone. So please do.
Yes.
Along with that, so not just my family making decisions for me, but if something happens to me, my family can automatically care for my children because children are also something that can be a guardian for your children can also be something that you name in a personal directive. So is it true that family can automatically care for your children?
Well, no, and there's, I guess, one important caveat to that. If we're talking a situation where two people are married, of course, and you have children together, and one of them becomes mentally incompetent, of course, the other parent is going to have full rights to parent your kid. What we're often looking at is if one of the spouses has passed away or maybe had a child on their own, okay, and so now, of course, there's no other parent available. We need to have what's called agents of minors designated designated. And we actually have a section for that in the personal directives, often done by lawyers, about who's going to be looking after the kids until either a guardianship order is completed, another order under the Family Youth and Enhancement Act, or of course, if you regain capacity, then obviously you're going to go back to parenting your own kids. But especially, it's important where we have two sets of grandparents that might be warring over custody, right? And so it helps the court determine who they should be looking at to take these children on, especially if it's reduced in writing, because we have considerations about, well, do you have certain religious convictions and only one set of grandparents actually follows that set of religious convictions? Is another set of grandparents wonderful people, but they live in another country? And it would be too much to uproot your kids who have established friends and community and schooling here. These are a lot of considerations. And so that's why it's also very important to name who are going to be acting as the agents of your minor children during your incapacity.
So hopefully, even in these first two myths that we've covered, what's emerging so far is these documents provide clarity, right? You name someone while you still have the ability to do so. You name someone to make decisions for you that you trust and that you want to making those decisions. You're not leaving it up to someone else or even for the court to decide in some situations, who should be making those decisions for you. And as you mentioned in both of the first two, Miss Jennifer, is really the concept of preventing family conflict. Families
Yes.
can be complicated already, and so you add in some, incapacity, and suddenly it can lead to more strife. So if you're clear on who you want making those decisions, then your family hopefully will respect that, and it can reduce that conflict.
Precisely.
So remember we said we were going to try and convince you why we thought these documents were important. So there's already two reasons why we think they're important. Okay, myth number 3 we hear. My family knows what I want, so I don't need a personal directive.
Doesn't matter. Okay? Doesn't matter. I know you think, but it's so clear. This is what I want. Doesn't matter. Has to be in writing. Okay? So if you're saying something to the effect of, well, I don't want any further treatments, okay, unless you have a personal directive that says this agent that I've named can say that, there's no legal authority for your family to direct a doctor to terminate any kind of treatments. So maybe you live longer and in a greater deal of pain than you want to because you're saying, no, I don't want to be kept alive by whether it's tube feeding or intravenous hydration, because that's one of the big things too, is maybe you don't have any appetite, but it's not going to be the lack of food that causes you to pass away. It's often dehydration that hastens death. And so if your medical team is still, for all intents and purposes, keeping you full on fluids, doesn't matter, unless it's in writing, your family's got no authority to do anything.
Absolutely. So the most important function of a personal directive is naming that agent. Because once you name that agent, the law says what they can do. It's very clear.
Yes. Yeah.
And
Oh, sorry, Jessica, go
no,
ahead.
go ahead. Go
I was
ahead.
just going to say, your agent is stepping into your shoes. They are your advocate. It's as if the doctor is taking directions from them and they are acting with knowledge of your wishes, your values, and beliefs. Okay? And so that's why without this document, you have no advocate.
And I think we talk about that. Maybe we can mention it now. Is what has to happen then is if you don't have an advocate, someone has to go to court to become your advocate.
Precisely. And so that's called a guardianship order. Now, guardianship, just to clearly remember, guardianship deals with healthcare decisions, where you end up living, with whom you may live and associate, all sorts of programs that you might be involved in, drug trials, maybe social groups, etc., that sort of thing. Trusteeship, which we'll talk about when we're doing power of attorney, is for financial decisions. But it's all governed through one office called the Office of the Public Trustee and Guardian. And so when we're looking at guardianship, if there's not a personal directive, your family then has to apply to the courts and notice is served on the Office of the Public Guardian to see if they are going to intervene. What's really difficult in this situation is that the Office of the Public Guardian is given 30 clear days. And so what that means is absolutely nothing can happen, even if you want to bring a rush court order, until the Office of the Public Guardian has had an opportunity to review and those 30 days have lapsed. So that might mean that you're in hospital for 3 to 6 months wanting to be placed into a long-term care facility, but nobody has the authority to do that. And when we're waiting for a court order, well, keep in mind, we have these certain timelines that have to be adhered to. We can't skip over that 30-day notice period. So if we're now even saying by some miracle you got it within 2 months, that's still 2 extra months that you are spending in a hospital, and it's not always wonderful staying in a hospital. Okay? You're not getting settled into a new way of life. You're not going necessarily to all of your rehab or social programs. Okay? You might be sharing a room with 4 to 6 people. You don't know that. So if you want to sidestep that whole issue, never mind the costs involved with getting a guardianship order, having the personal directive, it completely eliminates that issue. As soon as you have the personal directive, okay, doctor declares that you're incompetent in consultation with the agent that's named, and it's put into effect. And that is when a transition coordinator that works at a hospital can put you on the list to move you. Okay. But before that, if there's no personal directive, they can't do anything without a guardianship order.
Perfect. So again, another reason, time and expense of having to go to court to get a guardianship order if you don't have a personal directive. Okay, I think myth number 4 here, a PD only covers end of life care. And I think associated with that is that, who needs to make a PD? If I'm young and healthy, well, it only covers end of life care.
Indeed. And of course, tragedies happen. Okay. We all know young people who are diagnosed with early cancer or potentially are in a terrible car accident and have traumatic brain injury. Okay. Your life can change in an instant. So as soon as you're over the age of 18, you should consider making a personal directive. Okay? Really, really important things here. And we're not just talking, yes, as you pointed out, Jessica, end of life care. We're also talking about, okay, are we going to set you up on a drug trial? Do you need to now be put into a wheelchair? And are we applying for a subsidy on that behalf? Do we need to, of course, look at trying to put you into a social or an engagement program? What about physio? What about occupational therapy? Okay, all these things happen. And so it's just very limiting to believe that a personal directive is really there for people who are older, people who, have a lot of chronic health conditions. No, anybody who's over the age of 18. I would say, you know what, if you have a daredevil in your life who likes BMX biking, or somebody who loves any potential for collision, okay? So it can be football, it can be rugby, it can be those people who love going way too fast down some of the bike trails in our river valley, okay? But it also happens to people who are just driving along in a car and somebody runs a red light. It can happen to anyone. You're cleaning the gutters and you fall off the ladder. Okay? So just because you're either not old or a high octane individual, if I can call it that, everybody should really have these. And again, it encapsulates not just end of life care decision, moving you to a long-term care facility, what kind of care and programs you're going to be enrolled in, what kind of drugs you're going to receive, any kind of drug trials. There's so many decisions that the agent has authority to make under that personal directive.
Absolutely. Okay, so along that line, the next myth we often hear is having a personal directive means that I lose control of my personal decisions. So this thought of losing control.
Hmm. And so when you're looking at the document, it always talks about the duties of the agent are to do things in consultation with you. Now, again, there is a sliding scale when it comes to capacity. Maybe you have capacity to make some decisions, but not others. In which case, if you have capacity to make your own decisions, then the person who's named as your agent is supposed to play a supportive role, okay? They're not supposed to steamroll over your wishes and your desires. So the example that I often give to clients is, say you're on a round of various drugs and some of them maybe are working or they need to be changed because they can't have you on a certain medication for too long because it affects your kidneys or your liver negatively. And that's too hard for you to keep track of. I mean, I think, hey, I have capacity and I can barely keep track of that sort of thing. But then really your agent is taking responsibility and saying, okay, I'm making sure I'm communicating with the doctor about what round of antibiotics and any other kind of antivirals or medications that this individual's on. But if now the larger conversation is, okay, we don't think you can go home anymore, you're falling too much, and with the IV treatments, you need to be placed into a long-term care facility or hospice. Well, if you have that sense of, well, I can still tour facilities. And you know what? I remember that one of my friends was at a certain facility that I thought was very warm and welcoming and had great staff. That would be the one that I want to be sent to. Then that's what your agent is supposed to do. They're supposed to honor those decisions and they're supposed to help you. That you're supposed to participate meaningfully in these conversations, assuming you've got enough capacity to weigh in. Okay?
So it's not about losing control. It's also about getting support from someone that you trust to help you
Precisely.
make these decisions. Um, the other important thing to note about agents, and we've talked a little bit about this too, is that they have they have legal authority, which also means they have legal responsibilities. So as Jennifer mentioned, they are supposed to talk with you about making a decision if you're capable of doing so. And if they're not acting in your best interest or following your instructions, there are options available to checks and balances on an agent as well. So they're not, it's not about you losing control. It's about you getting their support. And if they're not doing that, there are options to get have them removed or whatever needs to happen.
Yes.
But it really, I guess, impresses the importance too of choosing someone you trust to be your agent.
100%. I cannot underscore that enough. You want somebody who's going to do right by you. And sometimes, it's not a snap decision that people are necessarily able to make. Sometimes that involves conversations with the person you're thinking about naming as an agent. Maybe they're not up for the task, or maybe they say, I think I would be too emotional to make that decision, especially if we're talking about a termination of all treatment to let you pass away. That might be too much on them. And so it's really important to have those hard conversations, as unpleasant as they might be, because it does the client no benefit to name people who are not going to honor their wishes, or, and this is something that we haven't talked about, they can choose not to act.
Mm-hmm.
Just because you name somebody in a personal directive does not mean that they absolutely 100% have to act as your agent. You can't legally force them. So
Mm-hmm.
that's why you need to make these documents and you need to have a sense of, have you named the right person for the job?
Yeah, I think what you said, like talking to them beforehand, don't spring it on someone and to have the conversation beforehand. I think of even, I have two sisters. And so when it comes to our parents, we've said, okay, who's actually going to be the best in an emergency situation? And,
Yes.
my one sister goes, nope, not me. Right. And
Yep.
so, there's my other sister and I are maybe function a little or make decisions with a more logical mind versus coming
Yep.
at it from an emotional perspective. So, thinking about who is actually going to be able to make those decisions too.
Yep. 100%.
Okay, our last myth on personal directives. Doctors can ignore my personal directive if they don't agree with it.
Not if they don't want to be sued, I guess is how I would answer that. No, if you've very clearly put in your personal directive, for example, if you have certain religious convictions that prevent you from getting blood products and blood transfusions, they cannot override it. But again, that's why it's really important that if you have certain religious values, that you reduce it into a personal directive. Okay. I happen to know that I think it's the Church of Latter-day Saints usually actually has has like a prescribed form that acts like a personal directive and is very clear about some of these things. So if you do have these kinds of religious convictions, absolutely. And same thing, maybe you're really saying, you know what, I really do not want any further treatment. I don't want to linger. Okay, do not continue. I know sometimes doctors are like, but, and it's like, nope, it's very clear in this directive. It says, do not continue if it's not going to improve my quality of life and would only serve to prolong my lifetime. Okay, if that's not what I want, doctors have to follow it. And as I said, if they don't, well, then that means we're potentially going to court. Okay, and they could get in some trouble.
And that's no different when you have capacity. Ultimately, the decision is yours. And so when you don't have capacity, your agent is now, as Jennifer said, your advocate. So they're speaking up. So it doesn't matter what the doctor wants. It matters what you as the patient wants.
And you know what? There's one myth that I just thought of
Mhm.
that's not on the list that we should talk about. Currently, and I cannot stress this enough when I say currently, as in not in effect now, but who knows down the road. An agent cannot sign you up for medical assistance in dying. That is the one thing that can only be done by you. So, in some of my cases with clients who are quite passionate about access to MAID, should that decision be right for them, I have to explain, sorry, we can't actually, there's no enforceability under the or the personal directive to complete this. So I put a clause in that says, in the future, should the legislation surrounding MAID, medical assistance in dying, change such that my agent is allowed to sign me up, I confirm I consent to same. Okay, so that is the one area where unfortunately that's our current blind spot. Okay, I don't know. We have a lot of blind spots when it comes to the current legislation, and that's why it's been tabled to 2027 to deal with some of these issues. As far as I'm concerned, this issue isn't even on the radar of our government officials yet about agents potentially having authority to sign somebody up for medical assistance in dying. Okay, so that's the one thing I will say that unfortunately a personal directive can't do if that's what you're looking for is like, well, I want, this adult child of mine that shares my values to sign me up for MAID, if I have a terminal diagnosis. Sorry, if you've lacked capacity, unfortunately, there's no signing you up for that program. Okay, so that's the one thing I did want to mention before we move on.
No, that's excellent. That is, yeah, no, absolutely. And like you said, there's some movement around that, not currently, but likely to be in the future. So we'll see what happens.
Mhm.
Okay, let's move on to some myths about enduring powers of attorney. So, personal directive, all about personal decisions, medical, where you're going to live, et cetera, et cetera. Now we're talking about enduring powers of attorney. So, financial decisions, anything about what you can own, your money, your property, your belongings, etc. So, one common myth we hear, if something happens to me again, my family can automatically look after my finances. They can go down to the bank, they can contact my investment broker. Is that true?
So unless they're joint on that account or that asset, it is not true. Okay. And so sometimes we see people who say, oh, it's okay. I've just given my child my PIN number. Well, you better hope that that child never gets caught by the bank. I can't tell you the number of clients, and really it's more like adult children of clients that have had very terse conversations with a bank representative who has caught them using somebody's debit card or is trying to access somebody's bank account and they say, oh, well, like I know their account numbers and their details. No, 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 no. The only way you can have any authority over that account or that asset is by way of joint ownership. So if you're not joint on the bank account, if you're not joint on the house, forget it. You're not able to deal with anything, at least not legally. And keep in mind, you might just be thinking about banking, but there's other things. There's changing utilities, okay? There's insurance. There, of course, is filing your taxes, and that's the really big one that people often forget, okay? Have a power of attorney. That person who signed as your power of attorney then has full authority to get information, to make deposits, to pay bills, to do anything you would be able to do lawfully by an attorney. The only thing that they cannot do is change your beneficiary designations. That's the only thing an attorney can't do. Okay?
And again, maybe we mentioned this here. If you don't have co-owners on your account, and we don't have to get into it, but I'll just say there are some pros and cons of doing that, adding co your children as co-owners on an account or co-owners of your property. So if that's not the case, and that's not always best in every situation, and you don't have an enduring power of attorney, then we're back to similar to what we talked about with the guardianship order. Someone's gonna have to get a trusteeship order.
Somebody's going to have to apply for that court order for trusteeship. You're 100% correct. And just to give you, because I know we have this kind of like later on, but I feel like it's a good idea to bring this up now. The cost of that. Okay, so I'd say I can tell you like what my rates are currently to do a will, power of attorney, personal directive for a couple. I charge $1,200 plus GST. I think that's probably within the normal range and probably somewhere in the middle. There's higher, there's lower, that sort of thing. My colleagues who do guardianship and trusteeship are charging between 3,500 and 5 grand. Okay. So if we're talking about what makes the most sense and you're saying, well, I'm trying to avoid, using a lawyer and that sort of thing, and you don't do your documents correctly, and I'm not saying that you have to use a lawyer. I'm saying if you don't do them correctly and now you need the assistance of a lawyer, it is going to cost you more than if you had seen a lawyer in the first place.
And I'll add on to that too, for these documents, they're not documents that necessarily have to be changed every year. If
No,
they're drafted properly and if a lawyer drafts them properly, they can last you the rest of your life.
precisely.
Unless something drastically changes, right? If a relationship changes or whatnot, but they can last you for a long time. And so sometimes it's just a one-time investment.
Yep,
And so think of it like an insurance policy.
precisely.
Um, um, Okay, so that's some good perspective on again, there's no automatic right to make those decisions and what is the investment up front that's needed to protect you. Okay, another common myth is I don't have much money. I don't own any property. So say you don't own a home. So I don't need an enduring power of attorney.
And again, all I can say is that's untrue. So if you don't have a lot of money, well, okay, your attorney is going to be there potentially to sign you up for a housing benefit. Okay, so they can apply on your behalf. Same thing if you're saying, well, I never owned an apartment, but now I have to be moved into a long-term care facility. That power of attorney needs to be able to set up automatic withdrawals to pay your rent. Okay, so it's not a matter of having millions of dollars or hundreds of thousands of dollars. No, we just want somebody to pay your bills, pay your taxes, and apply for any benefits that are available to you. That's really what they're doing. They're just doing your day-to-day banking. Again, so critical to think about this as, you know, everybody should have, as opposed to only if I fall into this category of people, only if I have lots of assets, only if I own a home. No, it's not about assets. I cannot stress that enough. Everyone who's over the age of 18 should have a power of attorney.
One thing I want to, we haven't necessarily talked about sometimes the interaction between a personal directive and enduring power of attorney, but we talked when we talk about personal directives, you say they might need to make a decision to move you into a long-term care facility, and that's going to require money or potentially signing up for a housing benefit. And so in that case, your attorney and your agent are actually going to work together, or they can be the same person. You can
Mhm.
name the same person to do both roles, but if they're not, then they're also going to work together. So now you can see how these decisions, even a personal decision has a financial aspect. And so that's why both
Absolutely
documents are so important.
correct. 100%.
Okay, so another myth along the same lines as we looked at about with personal directives is, I lose control of my finances as soon as I sign a personal direct or an enduring power of attorney.
So there's two kinds of powers of attorney that we frequently do. We do powers of attorney that only spring into effect once you've lost capacity. Okay, so until a doctor says, unfortunately, you don't have your marbles to understand what you're doing, you're trying to divest yourself of all the money that you have, you keep on giving to charities, not realizing you only have $20 to your name, and you're not paying your utilities and that sort of thing. Well, no, just because you've signed a power of attorney doesn't mean it comes into effect right away. It usually comes into effect with these springing ones upon a doctor declaring that you no longer have capacity. And again, there are some lawyers that say it has has to be two doctors. I myself, I just do the one doctor based on my own experience with the medical profession, knowing that at the end of the day, this kind of decision is going to be done by somebody who is a qualified capacity assessor. So in my opinion, there doesn't need to be a second sign off. But some people derive comfort in there being a second doctor that also signs off. Okay. The other one we do is called an immediate enduring power of attorney. And so now that one does come into effect as soon as you sign it. You are still able to go to the bank and do your own sorts of things. And powers of attorney like this, I do for my people who have mobility restrictions or my people who are frequently out of the country. So anybody, for example, who's in the armed forces and doing a tour, well, they want their spouse or their family member back here to be able to pay all their bills and everything. It has to be in effect right away. Them being mentally incompetent, well, no, that's not going to happen. And so there would be no point to that previous one I talked about, the springing one. We need it to come into effect now, okay? But again, you're naming somebody that you trust. And so some of the considerations that I usually tell clients to think about is the person that you're naming, can they handle their own money? Because if they can't handle their own money, they shouldn't be handling yours, okay? Also, do they have the time to do it? Are they decently organized? Do they procrastinate? If so, maybe again, not an ideal person. And then, of course, we look at, well, have they borrowed money from you? And is there a chance that maybe they would be treating your bank like their piggy bank? Okay. In which case, I don't recommend that. I want somebody who you know, who you trust, who is not going to do wrong by you. Because especially in the case of an immediate power of attorney, financial abuse could happen. Okay, it could happen even upon, the regular enduring power of attorney springing into effect. Why it is really important to name somebody that you trust. But until those certain contingencies arise, you're able to do your own banking, and even after they arise, you're still able to do your own banking. But I cannot stress enough, name somebody that you trust.
Absolutely. Okay, so we talked at the beginning about this interaction of these three documents. So we're focusing today on enduring powers of attorneys and personal directives. But we've talked a little bit about a will. And so sometimes we hear, well, I don't need an EPA or an enduring power of attorney because I have a will.
Yeah. Of course, will doesn't come into effect until after you die. There's no authority for your person that you've named as your executor, or the new term is personal representative. So just wanted to clear that up. Sometimes people are like, what's a personal representative? Same thing as an executor. It's just decided that it's a little bit more plain language because, of course, executor is grounded in Latin. And so, not as maybe comfortable for people whose English is a second language. Also, we had this, kind of feminine masculine. So an executor is male, an executrix is female. Now it's just personal representative, so gender neutral, or of course, if there's multiple, personal representatives. Okay. So unfortunately, when it comes to the will, you think you have so much power, you've done everything that you need to do. But again, it only happens after you die. So if there's taxes that need to be filed, property taxes especially, and like what if there's going to be, because property taxes haven't been paid in a number of years, the city trying to sell your house at public auction to try and recoup those. Big one is mortgage payments. Okay. If you are going to live for another 6 years in a long-term care facility and they've got no authority to deal with the sale of your property, so now it goes into foreclosure because they can't access your bank accounts and try and do anything with that, that's disastrous. The will has no help whatsoever. You need that power of attorney.
So as we always say, personal directive and enduring power of attorney while you're still alive.
Yes.
Will after you die. So you need all three of them. But you are going to die one day, so you do need that will. But you also, the personal directive and enduring power of attorney, we don't know what's going to happen, and so it's better to plan ahead than to not have a plan at all.
Absolutely.
Okay, another common myth we hear: it's too expensive or hard to make an enduring power of attorney and personal directive.
Well, as we talked about some of the rates, okay, there is a free downloadable personal directive form from the government of Alberta. So if you go onto Service Alberta and you Google personal directives, there's a template, and I can attest to that. That's what we used for my own mother. Okay. We did not have a lawyer prepare her personal directive. I was able to assist with that. Now, the one thing, though, that people often do not pay attention to is the instructions about who can be the witness on that personal directive. It cannot be the person who is named as an agent, nor can it be a spouse of the agent. You have to find somebody who's a witness who has no stake in this whatsoever. Okay. That's how you properly do it. Okay. So you're potentially doing your personal directive for free. Okay. And then powers of attorney, my powers of attorney, for example, I charge $400 plus GST to do one. And again, rates vary. Okay. But as I said, the cost for that guardianship and trusteeship application, well, $400 versus 3,500 to 5,000. And again, now, and on that, there are online options. I do not like online options when it comes to powers of attorney. I'm not saying that they won't be accepted, but where there's an issue often is the execution of them. Often, again, people don't read the instructions and it's signed off by somebody who should not be signing it. It's signed by the person named as the decision maker as the attorney, or it's, signed by a spouse or something of the attorney. No, 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 can't do that. So sometimes just hiring a lawyer to get these documents done properly, then you know that there's not going to be an issue. Banks appear to like ones that are done by a lawyer better than ones that are done online or kind of like a will kit or personal directive kit, other than of course the one that's offered by Service Alberta. Okay, that one's completely fine. But powers of attorney, especially, just because banks like that extra buffer where they know that if a lawyer's prepared it, that means that the lawyer has met with somebody, has talked to them about these situations, has assessed capacity, has even assessed if maybe there's an issue of what we call undue influence. So sometimes, we talk about elder abuse. Elder abuse is not always physical violence. More often than not, it's financial abuse. Okay. So banks trust those ones a little bit more. Also, you should know that some banks have their own form of power of attorney. So you could potentially do a power of attorney right at the bank, but that is only good for that specific institution. You cannot use a power of attorney you've done at Bank of Nova Scotia to file your income tax returns. Never mind, of course, not at ATB or BMO or any of the other banks that we have out there. Okay, so things to keep in mind. Whereas when you do a power of attorney, hopefully with a lawyer, okay, then you know that it's done correctly and it can be used everywhere.
And for a long time. Like
Yes.
it can often just be a one-time investment because that lawyer can also help you think through different scenarios that might come up and build those into your document. And what was I going to say on that? Yeah, so like we said, there are some other options out there. But if it's something that you're able to do and it's maybe as an investment, then to think of it that way as an investment into kind of your long-term planning. I was going to say too, you mentioned who can sign as your witness and who can't. The legislation for personal directives, the Personal Directives Act, and for enduring powers of attorney, which is the Powers of Attorney Act, they have very, very clear or I would say they're written very clear, but they have very specific instructions on what makes the document valid. So who can sign it, how it has to be signed, etc. And so if your document doesn't meet those requirements, then it might not be accepted. And so if you are going to do it yourself somewhere, make sure you understand what all those requirements are so that your document is legally valid.
Yep.
Because that would be the worst part, to get it done and then suddenly, there's a technicality and no one's going to take it. Okay, we have a few more minutes. We have a few more myths. So we've talked a little bit about this one already, but just in case we haven't convinced you, we often hear again, personal directives and enduring powers of attorneys are only for seniors.
I mean, the same things that we talked about under the personal directive situation apply here. 20-year-olds have bank accounts, okay? 20-year-olds have to file taxes. 20-year-olds have to pay rent, and sometimes, and this is the thing, even if you're renting a place, oftentimes landlords are really concerned if the family just tries to come in and clear out things because they say, well, I don't want to get sued to giving you access to this apartment and taking all of this person's stuff. I don't know who you are. Sure, okay, they're lamed up in the hospital with a brain injury, but this is their stuff. So as far as I'm concerned, unless you have power of attorney, there's nobody I can deal with except for this guy in hospital who you're telling me doesn't have capacity. Go get an order for trusteeship. Now you're paying a couple months extra rent because you can't deal with anything. Okay. And what if there isn't enough money in that person's bank account? Maybe the landlord says, well, I'm going to claim what's called landlord's distress. That's a legal term. And basically take everything and sell it. Because, of course, if they're out of pocket for rent, they can do that under the Landlord Tenant Act. Or I guess it should be, sorry, what is it called now? The Residential Tenancies Act. I think that's the official term. So thank you. Thank you, Jessica. So, but again, not just for seniors, okay? For anybody over the age of 18. Really, there's so many situations. It could even be, and I've seen this in one case, if you're in your early 20s and you know what, your parents have gone through a terrible, acrimonious divorce, okay? Under the legislation for trusteeship and guardianship, your parents have equal right to apply. So just when you think that they finally stopped fighting because you're old enough, there's no more support payments going on, that sort of thing, here you're throwing your mom and dad pitted against each other back into court, them vying about who's going to be in control of your healthcare decisions and your financial decisions. Do you really want to put your family through that? So again, has nothing to do with age, has nothing to do with whether you have a lot of money. Okay? We're trying
Right.
to solve who's going to be in charge. And one of the things that we do is and especially like with lawyers, we say, well, if we're going to name two people jointly, do they get along? If the answer is no, we don't name them jointly. Okay? Simple as that.
Absolutely. So the again, point is every adult should have them. You never know what's going to happen.
Yeah.
Something could change in a second. And so if you can do the planning now while you have capacity and while you can, hopefully take a little bit of time to think about it, talk to your agent, talk to your attorney or the people you want to name before you name them. Talk to them, have conversations about what you want to happen. Are they willing to act for you? Get the documents prepared and in place so that hopefully, if and the time may never come when you need them. But if the time does come, you're going to be really glad that you have them.
Mhm.
Okay, our final myth is that once I make a personal directive and enduring power of attorney, I can't change them.
And again, that's a big myth. As long as you have the marbles up here, as long as you have capacity to understand that we're making changes, you don't even need to have 100% capacity. As long as you understand what you're doing, you can revoke and change these documents at any time. Okay? And occasionally changes need to happen. I've seen sad situations where we've completed all the documents and then we found out that unfortunately one of the people that we've named, an adult child, has a gambling addiction. Okay, of course we're going to change that, right? Maybe we have somebody who, after several months of supposed to be acting as your immediate power of attorney, doing all the banking on your behalf, just has not gotten around to it, isn't talking to you as much as you'd like. You're not feeling that level of comfort. As long as you understand what you're doing and you can make new documents at any time, it's only when you permanently lack capacity that I would say these things are written in stone. So we're talking, of course, you're in the deep throes of dementia, you've had an extremely severe stroke, okay? Or, of course, traumatic brain injury, and there's no capacity and no chance of higher brain function, okay? But otherwise, of course, and as Jessica said, you may never need to update these documents. But if you need to, just call your lawyer or redo the documents that you've done, such as your personal directive. If you do it through the Service Alberta platform and use that template, they can be done at any time. You just have to make sure that you have capacity. Okay?
And one thing to note, if you are going to change them, I mean, there's um, you not necessarily wanting to change the physical document, like cross out things.
Yes.
You're going to make a new one and
Yes.
say that you revoke the old one. And revoking
Yes.
it is saying that the old one doesn't apply anymore. I want this new one instead.
Yes. Yes, because the big thing, and this goes for the will too, except for the will there has to be two witnesses, but you cannot simply just cross something out, write something in, and initial it. No, these documents all have a witnessing requirement. So unless that witness is watching that change too, it's not going to be valid. So what I say to people is spend the money, get new documents, get them done correctly. Some lawyers will say, well, if I'm just basically doing a couple of quick changes, I'm going to charge just a nominal fee as opposed to a whole, like, this is a brand new document, okay? Not all lawyers are like that. So, of course, that is a conversation when, if you decide to use a lawyer and when you're selecting one, you say, if I need to update these documents in the future, what would the charge be? And, I often, of course, classic lawyer answer says it depends. If you're doing a ton of changes, okay, I might charge you for a brand new will. But if we're just making one or two, it's going to be a reduced fee. So, a very important question to ask when you're looking for a lawyer to assist you with your estate planning documents.
Absolutely. And maybe just let's highlight some life situations where you might want to look at your documents again and make sure they still represent your beliefs, like you said, or represent your wishes. Maybe you discover something about a family member that you're like, they're actually not going to be a very good decision maker for me, or they're not responsible enough, or you get divorced or separate from your long-term partner. Someone dies, maybe your agent dies. If you haven't named a backup, then you're going to want to update that document. Otherwise, there's no one there.
Yep.
So relationship changes, life changes. You're gonna want to double check and just make sure that they still express what you want. And if they're still good, great. If not,
Yep. I'll tell you the times where I see the most updates, especially to powers of attorney, is when somebody has done a standard springing power of attorney that doesn't come into effect until they become mentally incompetent, and now they've had a severe stroke and there's paralysis, and they're in a wheelchair, and even though they're doing their rehab, it's going to be a long time. And so now we're updating that to be from a standard power of attorney to an immediate power of attorney because they're going to have to rely normally on their adult children in this case to do the banking for them. The other one, of course, is when we're seeing people who have been named as attorneys having health issues of their own. So, for example, if I'm dealing with a couple and they did their standard springing power of attorney that only comes into effect when they're mentally competent, but now one of the spouses now has Parkinson's or has dementia and that sort of thing. Well, the other spouse, it doesn't make sense necessarily for that, if it's the husband who has dementia or Parkinson's, to be the first choice, to be the power of attorney or the agent under the personal directive. Instead, they might update their documents to say, okay, it still only springs into effect when I lack capacity. We're not changing that aspect, but now we're going to remove my spouse because he's just not going to be up to the task. And instead, we're going to start naming adult children or a sibling or cousin, niece or nephew, whatever the case may be.
absolutely. Um, okay. Well, that's all the myths I have. But so hopefully, so our goal at the beginning was to set out and hopefully give you some good reasons why everyone should make, as Jennifer said at the beginning, an enduring power of attorney, a personal directive, and a will, which we didn't talk a lot about, but those three documents usually go together. And you mentioned this a couple times, Jennifer, that usually if you're going to see a lawyer for those documents, they're going to call it estate planning. So that you're going to put together these three estate planning documents.
Mhm.
And like you said, some lawyers charge if you're an individual, they'll do all three together. If for a couple, they'll do there'll be six documents, and they'll do them for a flat rate. And as we've said, every adult 18 years and older should have these documents. You never know what's going to happen, and so it's better to plan ahead. And if we don't plan ahead, we've talked a lot about some of these worst case scenarios. It can lead to confusion. It can
Mhm.
lead to even more costly legal processes for families. It can lead to conflict within families. And so really, when we talk about these documents, it's a service that you're doing for yourself because you
Mhm.
are choosing someone that you trust to make decisions for you when you can't. But you're also doing this for your family to
Yes.
provide clarity for them and peace for them. So in these times, and if it's being used, I mean, these are not usually happy moments when these documents are coming into play. And so you're creating some confusion rather than there being one other thing that needs to be dealt with. Hopefully someone can just get to making decisions and to get you where you need to be. So those are hopefully we've impressed on you the benefit of having these documents. We have just a couple minutes. So I'm just going to do a little bit of wrap up here. I'm just going to open up the Q&A and make sure. I'm just going to do a couple wrap up before I get to the questions. Um, as I said at CPLEA, we produce resources for you about the law. We have a new, an updated resources that we've done. So it's called Estate Planning 101. The link is posted in the chat. It's a booklet, so you can read it online. You can order a copy from us if you want an actual hard copy. And it talks about how, these three documents, enduring power of attorney, personal directive, and a will, how to make them, choosing an agent, what are some things you should be thinking about. A lot of the points that we've talked about today are summarized in this document. So if you want to take a look at that, that's there. We have some other resources about capacity and whatnot available on our website as well. So we've posted those links in the chat. We're also going to send a follow-up email after the webinar, and we'll include some of those links as well. We've posted also Jennifer's contact information. Jennifer, your website, River Rock Law, is posted there as well. So if you have any questions, you want to follow up with Jennifer, you can do that as well. We will be posting the recording of today's webinar on our YouTube channel. Again, you'll get an email from us with the link to watch that. So whether you want to take another, watch it again, or maybe share it with someone who also who should know this information. We do have another webinar coming up at the end of November. So that one is on law on TV versus real life, busting legal myths about legal shows. So if you're wondering if what you're seeing in Suits or Law and Order is accurate, join us on November 26th at 12 p.m. and we'll be walking through some examples and busting some of those myths. Finally, I encourage you to stay in touch with us. So our website is cplea.ca. We have a monthly e-newsletter that goes out, cplea.ca/subscribe, that you can join that. And again, you can follow us on social media. One of the last things before I get to the questions, we have posted a link in the chat for a survey. So we invite you to complete. It's just a 30-second survey. Tell us how we did today. And if there's any other topics that you would like to learn about, we always welcome that feedback. We have a couple minutes, Jennifer. Do we want to tackle some of the questions in the chat before we go?
Certainly. That would be great.
Okay, so the first question, I have a question about documents once the person has passed away. Should the advance directive documents be kept once they have passed away, and if so, for how long?
So
Great
it's not
question.
yeah, it is, and a very astute question too. I think, I mean, classic lawyer answer is usually it depends. So of course, because the power of attorney and the personal directive really have no effect after that, but there could be, if at some point in the future you had made some financial decisions as the power of attorney that people end up questioning during that time as your tenure, you should at least be keeping these documents. I say for security purposes, you keep them for 10 years after the person has passed away, plus an extra 3 years for 2 years to sue from, 1 year for date of service. Okay. So grand total is 13 years. Okay. That is like the upper level platinum standard. When I'm talking to people who are it's the one and only child, sole beneficiary, well, there's not really a lot of point because there's nobody to contest any of that, right? Doesn't really make sense. So it depends, but the upper level would be, I'd say, 13 years.
Perfect. Okay, next question. Is there something similar to agents of minors for adults with disabilities? For example, the person who's incapacitated is a sole caregiver for their adult son with Down syndrome.
So usually what we're seeing is an actual formal guardianship order. If we have somebody who's mentally incompetent and now over the age of 18, it's actually not through any of these documents because they don't have capacity. We're seeing it instead now through an actual formal guardianship application.
And if the guardian then one day loses capacity, the guardianship order will have to be updated, or it may name an alternate who would come into play.
Precisely, or if the guardian died. Correct.
Right.
Correct.
Can anyone apply for a guardianship order? What if there's potential for financial abuse or neglect and they would not want that person to be appointed as their agent?
Yes, and so that's why it's really important to do these documents. And when we say anybody, there's a priority, like a pecking order of who can apply and be given first right to. Usually the court wants to know why, if that person is still around and mentally incompetent, they're not acting. And it could be a reasonable issue. Is say, for example, both parents are in their 90s, and while mom still has capacity, dad maybe did all the financial planning and it's all over mom's head and it's too stressful to her, so it's a matter of mom renouncing. But if we're talking about people of equal priority or somebody who has committed financial abuse who has that priority, that's when we run into a problem because it's really hard to challenge that when you don't have that kind of priority. Because what standing do you have before the court? You can apply as an interested party, but the court won't necessarily hear from you because you have to prove to the court that you should be heard as an interested party. And that is sometimes a very difficult threshold to meet.
So great question, but again, another reason, another reason to prep these documents beforehand.
Yes.
Okay, another great question. What should you do if there's no one in your life you trust to manage your money or medical decisions? Is there a public group that manages this?
So, short answer is not really, other than the Office of the Public Trustee and Guardian. Now, the thing is back in the 70s, the Office of the Public Trustee did this crazy thing and advertised in the paper saying, "Hey, we're happy to act as your attorney and personal directive." Well, not anymore because they are inundated. Our poor Office of the Public Trustee is managing the files of so many individuals. So the only way you could appoint them is with their permission. And you don't necessarily know whether they're going to get it because they really want absolutely anybody else out there available to you to act. They will ask for friends, they will ask for nieces and nephews, even if they live in another province, sometimes even in the States, okay, and say, well, they're your better choice. So unfortunately, there's no group. There is the odd lawyer. Very few lawyers are willing to act as somebody's power of attorney. Generally speaking, lawyers won't act as agents. Okay, they don't want to make medical decisions for you. There's a very odd lawyer that will do that, but they're going to charge your estate their lawyerly fee. And we're finding, of course, not too many people can afford that. A lot of lawyers, including myself, are uncomfortable acting as somebody's attorney because, of course, I don't want to have fights with the family over personal items and that sort of thing. And if the house has to be sold and what I sell it for, you know what? It's not something that I signed up for. Okay. So unfortunately, no public group and privately. If you have quite a bit of money in your estate, I believe that the usual net value you have to have in your state is $750,000 in order to have a trust company appointed. If you fall below that amount, then they can choose to say, we're not acting. Okay. So trust companies definitely do have their places if you don't have anybody in your lives that you trust, but you have to have the cash. If you don't have the cash, they won't act.
Okay, I'm gonna breeze through these. There's two more questions if we can get through them. What happens if the someone who appointed under the power of attorney is suspected of misusing their power and taking money?
So that one is also a difficult one too, because it's again, you trying to apply to the court for standing. So occasionally people have tried to get the Office of the Public Trustee involved, but the Office of the Public Trustee will usually not get involved when there is a power of attorney because it's not
Mhm.
something that, they were in charge of that process. They'll get involved when there was an actual trusteeship order because they were served with notice. So oftentimes we see kind of these private citizens, whether it's friends of family or maybe another family member, applying to the court. But, again, very, very severe allegation. It's really unfortunate. Sometimes we can get police involved, but not all the time. When we're talking about elder abuse and financial abuse and fraud and that sort of things, occasionally. But again, we have limited police resources, okay? And especially when there's a proper power of attorney signed, right? Police are hesitant to get involved because it's not necessarily a criminal matter. It could be considered a civil matter, and therefore your go-to is hiring a lawyer to try and see if they can get the court's attention about revoking this power of attorney or forcing the person who's acting as attorney to formally pass the accounts so that the court can review it to see what exactly has been happening with this individual's bank accounts.
Perfect. Okay. There's a quick question here. Do you have more information about the assets for wills and estates? I would like more background information about the assets portion. I'm not entirely sure what that uh, I guess what I can say is if you look at CPLEA's estate planning 101 document, it talks about some of the different things you should consider and what your will covers. So if that's what you're getting at, for your assets for wills and estates. So I would say that would be a good starting point, and then you can always talk to a lawyer as well to help. They can help you figure out how to draft your will in an appropriate way. Sorry, I'm going to breeze through these questions. Okay, another one. Are there resources on what kind of conversations to have with the person you're considering to name? Yes. I don't know if you're there's again, I'll list in our estate planning 101 book in the first couple pages, there's AHS has some resources, Covenant Health has put out some resources. There's Advanced Planning Canada has put out some resources, not on the legal aspects of it, but just like how to have the conversation. So those are some ones I can think of. Any others to add, Jennifer,
I think
for
those are the big
resource?
ones. I think those
Yeah.
are the big ones. And what I like about them too is that they're groups that are more focused on the value specific and kind of breaking down what this is. I wouldn't say there's necessarily a ton. So you might be able to find some about how to broach the conversation. Some lawyers do blogs and that sort of
Yeah.
thing too, but I kind of defer to these organizations that have the skill to do this. And especially remember, if you are looking at a blog online, please at least make sure it's done by a lawyer that practices in Alberta, not in another jurisdiction. There are jurisdictional differences. Do not be looking at laws for lawyer blogs for Saskatchewan. Do not be looking at lawyer blogs for the UK or the US. Okay, please remember Alberta specific.
Perfect. And the very last question, so if you name an personal directive who lives in the US, there's some tax complications there with US taxes. Is it the same if you have a power of attorney, if your attorney is also in the US?
Classic lawyer answer, it depends. And so the issue with a trust, okay, and we've seen some issues. So first of all, there's logistical issues. If you are banking and have all of your assets with a credit union that only exists in Alberta, having a US or even a BC attorney is not going to be helpful because there's not going to be a bank and a branch available. Same thing, of course, with US attorneys, national banks, like there's not necessarily a BMO or a Scotia or that sort of thing, okay? The other thing too is when they're holding money in trust, there is this issue of, doing these trust returns and the residency requirement. My understanding of speaking with accountants, because this is more of an accounting question than a true legal question, okay? And that's why I don't know everything about this. So I highly recommend you get qualified accounting advice on this, is that accountants they don't even want to deal with that issue. They don't even want it to come up as a potential for, oh, are we now going to have to do any kind of filings? Are we going to have to treat this person's account and this person's tax filings as a non-resident of Canada because their attorney named in the document is a non-resident of Canada? We highly encourage at least there to be two, then in that case, one that is resident of Canada, then the other one can be non-resident of Canada, or you name somebody who's resident of Canada. Okay. And that just eliminates the issue. I know sometimes people say, well, I really don't have anybody else. In which case I say, well, then it is what it is. And it means that you end up having to do more tax filings and pay more taxes. It is what it is. But get accounting advice from a qualified accountant. That might be somebody who's not just your regular accountant. Maybe it's a tax accountant. Maybe you have to do some cross-border stuff. There are some larger accounting firms out there that even have like a US tax division to
Mhm.
answer certain questions about, what are the filing requirements.
Perfect. Okay, well, we've gone over a little bit, so we'll stop it there. But I want to say a huge, huge thank you to Jennifer for joining us today. I thoroughly enjoyed our conversation, and I hope everyone who's tuned in has as well. And like I said, we have a few more webinars coming up, so make sure to check out some of the links we've posted in the chat. And I already saw one person that commented that they'll need to rewatch the presentation. Absolutely, we'll send you an email when the post or when the recording is available on our YouTube channel. Any final thoughts, Jennifer?
Just thank you so much for organizing this, Jessica. What a wonderful topic. I hope that our attendees got something out of this presentation. I hope we were able to successfully bust these myths. And again, thoroughly enjoyed this. Such an incredibly important topic. And I'm glad that CPLEA is focused on this because I can't tell you enough how much of my job in this area is education, education, education. So you guys are really an invaluable resource to Albertans, truly.
Perfect. Thank you so much. And on that note, we're going to say have a great rest of your day, and we'll see you next time.